Hello, and welcome back to IVF Daddies, the podcast that you want to listen to today because we have the amazing Rich Vaughn back from International Fertility Law Group, who from a previous season spoke to us about some of the legal parts in the surrogacy process. However, today we're going to be talking a little bit more about some of the new legislation that is coming out in the United States by the current 47th President Trump on American citizenship and birthright. Rich, first of all, welcome back.
Thank you, Richard. Always a pleasure to speak with you.
So, this week has been monumentous. Monumentous? Is that even a word? No, monumental.
I'm sure Trump will make it a word.
Yeah, he'll make it a word, the best word ever. This week has been monumental in a lot of executive orders being issued by President Trump. One of which was protecting the meaning and value of American citizenship. So can you tell us a little bit about what is the US birthright citizenship situation?
So birthright citizenship is enshrined in the Constitution. It's part of the 14th Amendment to the Constitution in the U.S. That basically says, and it's always been interpreted to say and mean, that anyone born on U.S. soil is a U.S. citizen, period. Full stop.
Who wrote the Constitution?
The founding fathers of this wonderful country. And then the amendment, it was an amendment to the Constitution. So that goes through a very rigorous process where the two houses of our legislative branch of government have to propose an amendment, and they have to basically approve it by 2/3 majority. Then it goes to the states, and they have to pass it at a 75% rate for that to become an amendment. So this also means that changing this would require that high level of consensus. Basically, we don't agree on much in this country anymore. There's very low likelihood that this could be changed by a constitutional amendment, which I think is the reason behind the executive order.
So an executive order, does that override the Constitution?
It does not. So any executive order which instructs a government agency to do something that is illegal, basically it's not going to go forward. It is being challenged. There were lawsuits filed on Monday evening, the same day that the executive order was issued. Those lawsuits are now less than 72 hours old, but challenging his right to sort of say that we're going to do something contrary to what the Constitution says. The nuance here is that the executive order is asking or suggesting that there be a new interpretation of the language in the amendment. So, such that if a person is born to people who are here illegally, they're not entitled to U.S. citizenship. There's actually two prongs to the executive order. That's prong one, that any children born to people who are here illegally are not automatically granted that citizenship. Prong two, which suggests that if there are people who are here legally but on a visa, B2, H-1B, work visa, so they're here legally but temporarily, that children born to them on U.S. soil would not be entitled to U.S. citizenship as well. So those are the two prongs of the executive order, and I think it's fairly clear that in the surrogacy context, prong one would not really apply, but there's some concern over whether prong two could apply.
Okay, so to that point, why would prong one not apply?
Because intended parents from other countries who are coming to the U.S. to engage in surrogacy, they're not immigrants to the U.S. They will be here on whatever visa status they have to get to the U.S., and that's a legal status. So prong one is about people who are here illegally.
So literally people that are living there without the right, in effect, to live there. They have a child, then because their child is born in America currently, they can get a passport. The child can get a passport. Can the parents get a passport because their children have a passport?
No, it doesn't happen like that. The child could potentially sponsor that parent when the child is 18, but obviously that's a long period of time, and it's not an automatic thing. So, I mean, one of the major concerns during the campaign, during the first Trump administration, was about curbing illegal immigration. So that's definitely what prong one is directed to.
And therefore, so as you were saying, because, so for example, I'm English. If I go into the United States, I go in on the US visa waiver program. I'm there legally, but I'm not living.
Right.
And I think,
Those parents are not immigrating to the U.S. for long-term residence in the U.S.
okay. So then question two, which is part, you said if you're there on a visa, then your child would not be entitled to a passport. Obviously, I would then be entering on the equivalent of a visa to be in the United States, not to live there, but to be there temporarily. That means that my children would not have a US passport.
That's if this order stands. Let's remember that this is being challenged, and what's likely to happen, there's no way to predict this certainty, but what's likely to happen is the courts will issue an injunction to prevent implementation of this order while the lawsuits are pending, and that can take months to clear up. So, I mean, I think that's our expectation at the moment, but what you're asking is what if it does go through? And there's a lot of uncertainty about what prong two means. Now, based on sort of the claims during the campaign, the claims during the first administration, Project 2025, the real issue I think that prong two is intending to address is the issue of curbing anchor babies and chain migration, and not to intended parents who are coming to the U.S. to engage in surrogacy where it's safe, legal, ethical, etc. The anchor baby and chain migration issue is a situation where, let's say, a woman from a different country is pregnant and she comes to the U.S. so she can give birth and the baby can be a U.S. citizen, and then eventually have an option for that parent to also become a U.S. citizen. That's the chain migration piece. Now, anchor baby and chain migration are not formal legal terms. They're just colloquial phrases that most people use to describe this issue. And so I think prong two is meant to curb that. That's been something that's been discussed quite a bit in the campaign and obviously in the first administration. The issue, though, is the executive order does not really clarify that. It's not directed to that. And that's been the problem with a lot of Trump's executive orders in the past, is they're not drafted with a lot of clarity. So that's probably what will be part of the litigation as it unfolds, as to seek clarity on what this really would mean. That's if it's not struck down completely to begin with.
Okay, so current status is, say, for example, I'm expecting a child because I think there was a 30-day period where nothing's going to come into effect. But say I'm not pregnant. Say my surrogate I'm just Christmas weight. Sorry. It was a fun Christmas. I ate a lot. I'm sorry. God. Anyway, my surrogate is currently 6 months pregnant, which means that I'm going to have a baby in March or April. Assuming nothing happens with the courts and they strike it down, we know what's going to happen. But if the courts say, hang on a sec, this executive order, we don't understand it, we don't know what it means, put a moratorium on it, does that mean that everything just continues as it is today?
Yes. So if the courts basically issue an injunction to prohibit implementation of the order, then the law of the land continues in place as is until the litigation is resolved. And if the injunction is issued, then getting the litigation resolved will take months because there's a lot that's unclear in this executive order.
So
there's another piece to this too that I just want to mention. Say that all the affected agencies of the government that are impacted by this order have to issue their guidance as well within 30 days. And without clarity in the order, those agencies also can't issue guidance. So there's a lot left to be clarified. So this will take months and months, in my opinion.
So then a question, who issues the injunction? Can anybody issue the injunction, or does it have to be a certain court?
Well, the courts that are currently hearing the case are the First and Ninth Circuit. Those are federal courts in the U.S. So that's the sort of the initial level, the trial level, if you will. So they will hear all the facts and discuss the law and issue a ruling, which would likely get appealed because one side won't be happy with the outcome. Then it will go up to the appellate level and potentially to the Supreme Court. It could even potentially go directly to the Supreme Court from the circuit court. It could start with the first level, the trial court.
And historically, how long does that take?
Depends on the severity of the issue. This is a pretty major issue to sort of say that we're going to change how we interpret the Constitution. So this could happen quickly. I think the injunction is important because there's a lot of clarity missing in the order. A lot of people sort of in limbo with current pregnancies. So, we have a concept in our Constitution, I should say. I don't know if that's sacrosanct anymore, but called due process. And so you can't really apply new rules without giving people due process and due notice. I think we're going to have to issue the injunction.
Yeah, because I'm getting a lot of messages from people who are panicking. They're like, what does this mean? Oh my gosh, what's going to happen to me? So I think the biggest message is hold fast. You're going to be okay, because the clarity is going to arrive very soon as to what the situation is, i.e. there's going to be an injunction or not. And then that will lead into a much bigger debate as to what this actually means.
Yes, exactly.
So then a question for you. Say, for example, this does get approved and, there's a logic behind it that says you're not an American, your parents are not American. Why would you be an American? Aside from being born in the United States. So I understand the logic behind it. I don't agree with it, but I understand it. Say that is upheld. What then for those parents who have a pregnant surrogate that are not from the United States? What could potentially be an outcome?
Well, then, of course, the main issue is getting the child back home, right? So without U.S. citizenship, they're not able to apply for and obtain a U.S. passport, and so they will need some other travel document to get home. During COVID, certainly in the early stages of COVID, we were in a similar situation for different reasons. The State Department had basically closed the passport offices and or they were taking 4 or 5 months to get passports issued. So during that period of time, there were alternative options for getting people home. Many countries issued temporary travel documents, so their intended parents from those countries could get their child those travel documents to travel back home. Temporary documents such as a laissez-passer, which is a French phrase for let pass, essentially. We're hoping that
speak French.
I try.
So you could in effect have a surrogate. So say, for example, I'm from England. I go to the United States, my surrogate has the baby. I would then, as a genetic parent, be able to apply for a passport for that child and then travel home on the UK passport to the United Kingdom.
Or the UK emergency travel documents. They may not issue the passport right away.
Okay.
So sometimes they will, sometimes they won't. None of this is a guarantee. There was a period of time where during COVID, the UK in particular was highly efficient in getting these issued within 24 hours. As that emergency sort of faded, that process became much slower. So I think we're back to sort of the old days, but a crisis begets new ideas, new alternatives, and I think that we'll go back to that.
And I think that's a really important point that you bring up. Basically, there is a current process. It may change, but if it does, there is a solution.
Yes, there's always a solution. There's always another way to solve a problem. So that's been our approach to this for the last 33 years. We do have changes in the law from time to time in assisted reproduction. This is one of them, and it affects our international clients more than others. And we're going to come up with other solutions. IFLG and all of our reproductive law colleagues are actually sort of talking a lot right now, as you might imagine, organizing town hall meetings, if you will, to discuss and implement options and discuss the viability of these options and alternatives. So we're not going to come up empty-handed.
And that's amazing, because I think that the panic again is the unknown. There's a lot of, when you look at the United States for surrogacy, you're going into this thinking this is gold plated. I understand from the start what's happening. The process is X, Y, Z. And now, of course, it's like, oh, Z's not happening. It's going to change. But there's going to be an alternative.
There is. There will be. For 33 years, at least, in our practice and other well-established law firms, everyone has obtained their court order. Everyone has obtained their birth certificate. Everyone has gotten back home. So we'll continue to make that happen.
Amazing. Rich, thanks so much for jumping in so quickly on this topic. I know there's a lot of questions sliding into our DMs, so hopefully this will help to allay some of those fears. As usual, you're a superstar. Thank you very, very much.
My pleasure.